Court calls case of People versus Joseph Hafner-Kanter.
Alex Warren, Green Hafner-Kanter.
Here, Your Honor.
Can you state your name?
Joseph Hafner-Kanter.
All right, what are we doing?
Your Honor, we're asking for a preliminary examination at this time.
Discovery is complete.
Believe so, Your Honor.
People have their witnesses available the 13th. Preliminary examination in person, January 13th, 2026, 9 a.m. before me.
Where?
Bond continued. Thank you.
I think the last time we were here was December the 4th.
Pardon?
Last time we were here was December the 4th. I have a violation dated December the 9th. Bond violation, of course.
And we are in receipt of that, Your Honor. I did review it with my client.
You have a bond violation? I do. Behind that, I need these in the front.
So Your Honor, it does seem to indicate,
We were here last on what day?
I thought December the 4th.
Yes, I have December 4th. And I've got,
So it does appear that these tests were in the interim period between the last time we were here and this
Mr. Allen.
with positive alcohol blows on the silver link.
We've got a positive on December 8th. And then missed tests really through the 9th, early into the morning. So the 8th was at 11:37 p.m. 0.07. And then 04, probably the same alcohol, maybe a little bit more, by 8 a.m. that morning. So some 8 hours later, he's still blowing numbers. Except that then a little bit later, it popped up and then went down. So it looked like he was continuing to drink. Then the worst thing happened. They spoke with him. And he said he didn't have any alcohol.
And Your Honor, I believe Mr. Hafner-Kanter is changing his position on that now.
Really?
He
Yes,
did
sir.
appear on the same day that this violation report was submitted. He appeared before Judge Frushauer to be arraigned on a misdemeanor OWI. The misdemeanor OWI date of the alleged offense predates this case. I think it was just authorized later due to lab results. But nevertheless, he appeared for arraignment knowing that this violation was there, and it was addressed at that time by Judge Frushauer, who had him taken into custody with a $5,000 10% bond. I think the condition of that bond
On this case?
he was taken into custody at the time of his arraignment.
You're saying two different things to me. Her taking him into custody at the time of the arraignment is
Mhm.
one thing. If she's taking him into custody on this case, that's a different thing and not something that I see in this file.
And you're correct. What happened was after the court considered this bond violation and received the report from his tether agent, bond was set in the amount of $5,000, 10%, with the condition that he be fitted with a scram tether before that bond shifts to a personal bond. So he was fitted with a scram tether. He remains on that scram tether since December 9th, and I don't believe he's had any violations. Mr. Hafner-Kanter is employed and has stable housing with his employer in Saline. Your Honor, I would ask the court to consider continuing his bond because I think him being on a scram tether is kind of the constant reminder he needs not to drink. I will note the present offense. I don't believe there are any alcohol related allegations, but of course he does have a misdemeanor OWI, and he admits he has a drinking problem.
Yeah, but this response from the people.
The people are glad that he has now a scram order on the OWI case that's pending before Judge Freshour. However, it's still a violation in this case to have been drinking. I'm not sure. I know the court generally will issue warrants pretty quickly when these things sort of come through. I'm not quite sure what happened here, but no matter what, it doesn't.
Was there a warrant issued on this one?
It does appear to the people that alcohol is a significant problem for the defendant. It appears that SoberLink is not working. So I would ask that the court at the minimum order the scram in this case as well.
Did he take the ETG?
Doesn't look like it from this report.
I did not give you one.
So there was a warrant issued on this one, okay.
Okay.
Is it still out?
For Mr. Hafner-Kanter?
Yeah.
Okay.
No, I do not see that warrant.
Oh, you do not see that
I
one.
do not see. No. So he was, the report says, I advised him to report to community corrections for an ETG urine test by end of the day. This is on 12/9. He said he had court and only had transportation there, doesn't have any money to take the urine test. I advised him a violation be sent, and I was affording him the opportunity to take the ETG test to provide results with my report if in fact he was not drinking. And I just confirmed with Mr. Cook. Mr. Cook informs me that the defendant had a positive BAC coming into court. I'm not sure if that's related to this violation report or if it was actually going to court, but it does all appear to be on the same date, that December the 9th sort of time frame.
So when did he appear before Judge Freshour?
It looks like December the 9th,
That's correct.
What time?
9-ish in the morning.
So she may or may not have been aware then,
She was aware, she remanded him and.
but was she aware that he was intoxicated?
Mr. Cook's note indicates, and his communication to me indicates that, he had a positive BAC coming into court. I'm assuming that means he was blowing numbers at court. And I know that community corrections was there.
Okay, I'm pretty much done. I mean, you drink coming into court, you drink in violation of my bond. I saw you 4 days beforehand. And no,
May I speak?
we don't do that. Say whatever you want.
Your Honor, I think what Mr. Hafner-Kanter wants the court to consider is that since this string of events leading up to the court date on December 9th, I think he has pivoted and changed his position from denying
So let
his
me get this
problem.
right. You're telling me that all of a sudden everything has changed. On December 8th, he's drinking. He's drinking well into the morning on December 8th. He has to appear in court, can't stop drinking, and then ends up at court that day. He talks to community corrections, I think, on that same day and just is absolutely lying to them. And somehow between now and that date, he has made a certain epiphany has occurred and he's made some miraculous transformation. Is that what you're telling me?
Your Honor, I understand the court's concern. Mr. Hafner-Kanter, when were you released from the Washtenaw County jail? Was it the following day or this?
I was there for a week. I think I was released on the 19th or the 18th.
So, Your Honor, he's strung together 10 days on a scram tether with no issues whatsoever. And I think that's what he wants the court to consider in reassessing bond here. I would ask the court to continue his bond based on the fact that he's come into compliance since being placed on the scram tether.
He's in violation on my case, goes to another court drunk.
And Your Honor, I would like to correct my record I made to make sure that it's accurate. Mr. Cook has let me know that he doesn't know if the defendant was individually touched at the court, but because he had the 0.04 30 minutes before the judge saw him, Mr. Cook's note was that he was drinking. So I apologize if that was confusing at all. I just want to make
So he wasn't breathalyzed at court.
now that Mr. Cook is aware.
Where
But
it's because it was 30 minutes before, there was an assumption that, which is a good assumption.
it's pretty fair, yeah.
Anything else?
Your Honor, I know Mr. Hafner-Kanter's been in constant contact with his community corrections agent, and I know that his 3-year-old daughter, who he takes care of, is his biggest concern. I think he was dealing with some stress regarding a custody situation with respect to his daughter, and
He's violated my bond. And then absolute disrespect showed up at another court, still under the influence of his drinking event that violates his bond in this case. And he's appearing at that time on an OWI. And he's not in any treatment. Anything else?
Nothing from the view.
nothing further, Your Honor.
Bond revoked, defendant's remanded.
Your Honor,
Yeah.
and
The 13th is.
And with respect to that date, he does appear in district court on that same date. I'm not sure if the court wants to move it or if the jail would be able to accommodate that
District court where?
for the OWI case.
Well, he wouldn't exam until much later.
Which judge is the exam? Thank you.
Thank you, Your Honor.
What ultimately decided this case wasn't just a single failed test or one bad decision, it was a pattern, and the court made that very clear. The judge wasn't looking at this in isolation, he was looking at the timeline, the missed tests, the positive alcohol readings, and most importantly, the defendant showing up to court while still under the influence, all while on bond. In the eyes of the court, that's not a mistake, that's a direct violation of trust. Bond is not a suggestion. It's a legal agreement. When a judge releases someone on bond, especially with conditions like sobriety monitoring, that release is based on one core assumption that the defendant will follow the rules. Here, the evidence showed continued drinking, inconsistent explanations, and statements to community corrections that simply didn't line up with the data. That credibility issue mattered a lot. The defense tried to pivot to a redemption argument, stable housing, employment, family responsibilities, and recent compliance on the scram tether. But the judge wasn't persuaded, and here's why. Compliance after being caught doesn't erase the violation itself. Courts routinely look at whether change happened before intervention or because of enforcement. In this case, the judge made it clear the turnaround came only after custody, after tighter controls, and after the bond had already been violated. Another key factor was accountability. The court emphasized the disrespect shown by appearing intoxicated in another courtroom while still under bond in this case. That detail carried weight. Judges expect defendants to take court obligations seriously, and when someone arrives impaired, it signals a lack of control and a lack of respect for the process. So when the judge revoked bond and ordered remand, it wasn't an emotional reaction, it was a logical conclusion based on risk, credibility, and repeated non-compliance. The message was unmistakable: without treatment, without honesty, and without demonstrated responsibility over time, supervision alone is not enough. Now here's the question for you: should the court have given one more chance because of recent compliance, or did the defendant already exhaust that opportunity by violating bond and showing up to court intoxicated? And more broadly, should monitoring replace treatment when alcohol is clearly the underlying issue? Cases like this highlight how quickly freedom on bond can disappear and how seriously courts treat honesty and self-control. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.